Welcome back to this final segment in this English legal system law session on juries. We've looked at the history, we've seen some of the issues in relation to juries, and just before the break, of course, we were looking at eligibility and certainly where the jury is somewhat today. There are a couple of other principles that I would want to touch on, not least verdicts, and certainly I also want us to consider what are the arguments for and against retaining the jury. Now, if we consider jury verdicts, it's one of the things where we come from a background of unanimity, where we're looking for a jury who would generally be unanimous in all the situation. And frankly, again, when you make a comparison, for example, a state like New York, you see that there is unanimity when it comes to verdicts, and there's always this feel by defense lawyers that they just want to get that one person who will not go with the rest of the 11. But in the UK, of course, you can have a majority verdict, so you can be convicted on 10-2. Worst case scenario, you might even be able to be convicted on 9 persons finding that you are guilty in certain circumstances, of course. Now, that again raises questions about the idea of the jury being the guardian, as it were, of the defendant's rights. Because if it starts off that you're looking at 12 of your peers, as it were, and then you are then sent down by 9, it raises questions. Now, what are the arguments, for example, for retaining the jury? Well, there's this idea of public participation. There's this idea of judging on conscience. So it's not just a judge who knows the law, but this is just the average person looking at it from a sensible, common sense approach. The arguments against retaining the jury, of course, is that they lack competence. Equally, when you look at situations with perverse verdicts, that also goes against retaining the jury, arguably. Now, an interesting case is the case of Grobbelaar and the News Group, because this was a defamation claim where we have, I think it was the goalkeeper for Liverpool Football Club. He had brought an action against the Sunday newspaper saying, which had said rather that he had accepted bribes to fix matches. Well, he said he did make statements that he accepted money to fix matches, but he said he did it because he was actually setting somebody else up. So it really wasn't that he was doing it to accept the money, but it was being done in order to catch somebody else out. Well, the jury believed him, albeit that it appeared that it wasn't the strongest argument being made. The jury believed him and they awarded him £85,000. Well, the newspaper appealed and the Court of Appeal said, yes, it was in fact a perverse verdict given the overwhelming evidence. But the House of Lords disagreed with the Court of Appeal, and they said, no, if it is that you're looking at the jury making such a decision, then it should only be in very rare instances that you overturn a jury verdict. Now, there's also the issue of bias, and frankly, again, the idea when you look at the jury pool, again, Britain and its multiculturalism, you may find by and large that there are not the numbers of ethnic minorities, for example, and certainly there may be biases as against certain ethnic and racial groups. So there's also that consideration. The big thing that has caused, the next topic I'm going to lead into, but the big issue around juryless trials or not using jury for trials is this idea of jury nobbling, meaning interfering with the jury. So for example, where there are big fraud cases or terrorism cases, then the idea is that you ought to, for example, ensure that you are dealing with persons who are not going to be affected. And so if you have a jury, then it may be too much on police resources to protect them and all this discussion. Equally, when you look at some of the big cases which have collapsed, there's this idea that, well, the jury doesn't quite grasp the understanding of what's happening here. Now, whether or not juryless trials is a good or a bad thing, it has been heavily debated, and certainly as we will see shortly, there have been a couple of cases where it has been considered, and certainly one case in particular, the Heathrow Heist case, where they considered that they would sit without a jury. That said, the last point I would raise in respect of just general principles is this whole idea of the absence of reasons for making their decisions. So when you look at the jury, there's this idea that they don't have to give reasons. So they don't have to say, well, we have considered the evidence. They can just come back, give a guilty or not guilty verdict, and that's the end of the matter because the jury room is sacrosanct. All right. Bearing this in mind, how do we look at possibly reforms, or what are the reforms that have been bandied about? Well, what is the reality and the desire for reform is that we see in recent years in the UK, there has been this intense debate as to the future of the jury in criminal trials. Now, the British government has been charged with attempting to remove, well, when I say charged, they've been criticized for attempting to remove the right to jury trials through its various attempts to decrease the defendant's right to determine the mode of trial. Now, mode of trial is when, of course, you're in an either way offense. Remember, I explained that earlier to say if you're looking at certain types of offenses, you can have either way, you can have indictment, or you can have summary. Now, if the statute provides, then it usually will be up to the defendant in an either way offense to select where he wants to be heard. Well, we see the Criminal Justice Mode of Trial Bill, the first one in 1999, would have removed the need for the accused to consent to be tried summarily when charged with an either way offense. Now, the bill was not enacted. The government again tried with the Criminal Justice Mode of Trial Bill number 2 in 2000, but again it was not enacted. When we look at the old review of the criminal courts in 2001, it was proposed that magistrates should decide where the defendant is to be tried. Now, as a compromise, the Criminal Justice Bill 2002 increased magistrates' sentencing power so that fewer cases would need to go to the Crown Court. Now, the Criminal Justice Act in 2003 also amended the Juries Act of 1974, and one of the things it did was to abolish certain categories of ineligibility. So, for example, certain excusals as of right were done away with, except, of course, mental disorder. Now, when you look at the situation nowadays in terms of eligibility, there is no bar in respect of a judge or a clergy or an MP and the like being not being able to serve. Now, the idea, of course, is to make sure that there is a broad cross-section of persons who are able to serve. Now, the Act also makes provisions for applications by the prosecution for certain types of fraud cases to be conducted without a jury, and that's Section 43 to be implemented. And it also makes provisions for some cases where there is a danger of jury tampering for there to be no jurors as well. And that's under Section 44. So if you're discussing any sort of reforms in this whole context of juryless trials, you need to make sure that you are familiar with Sections 43 and 44 of the Act. Now, under Section 43, in cases of serious or complex fraud, the prosecution, as I say, may apply to a judge of the Crown Court for the trial to be conducted without a jury. If the judge is satisfied that the complexity or the length of the trial, or even both, are likely to make the trial too burdensome to the members of a jury, that judge may decide that in the interest of justice, the trial should be conducted without a jury. Now, in deciding this, of course, the judge should look at any steps which could be taken to reduce the complexity of the trial or indeed the length of the trial. Now, if the judge does decide, then the Lord Chief Justice or such judge as is nominated by him must approve the decision. Now, in the case of jury tampering, there would have to be a substantial likelihood of tampering taking place, which would make it necessary in the interest of justice for the trial to be conducted without a jury. Now, when we look at the relevant statute, as I say, you are looking at, for example, sections 43 right up to 50 of the Criminal Justice Act 2003, which provide far more detailed provisions for non-jury trials. And I would urge you to have a look at this, because it looks at how the application is made. It looks at what the trial judge must do. For example, he must ensure that there is evidence of a real and present danger that jury tampering would take place, for example. So the idea is that juryless trials is not just a situation where the prosecution is hell-bent on winning. Now, this is clearly a stringent test when you look at it, and the judge must be sure that police protection would not prevent interference with the jury, for example. Now, we have seen a couple of cases which, of course, have come before the courts in recent time, and we have seen how the courts have considered them. Well, to date, there has only been one trial without jury. The conviction of the defendants was affirmed in the Crown against Tomey, Blake, Hibbard, and Cameron in 2011. Now, Lord Chief Justice, is in stressing the value of a fair trial. He said that a trial without a jury is not in breach of either the common law or the European Convention on Human Rights. He said the checks and balances that relate to trial without jury are sufficient to guarantee that a fair trial has taken place. Now, the fact that appellate courts have a review function of trial courts also mean that allegations of breach of a fair trial principle can be considered by Superior Court. Now, Lord Judge went on to make some more general comments on the nature of jury trial, and he said, well, jury trial is described as a right in order to emphasize its importance, but he says it is not a right which can be and from which statute couldn't, for example, circumscribe these rights. The point being made is, he said there may be statutory provisions which affect this right to jury trial. And he does make a valid point when he says that the European Convention on Human Rights does not say that you have a right to a jury. You may, of course, consider Article 6 and consider that based on Article 6, for example, a right to a fair trial might include a jury trial, but there is no right in that regard. Now, this whole idea of juryless trials is not new. Please bear in mind that there are other provisions of law, for example, Section 17 of the Domestic Violence Crime and Victims Act of 2004, which does provide for trial in certain situations without a jury. Equally, when you look at the situation in Northern Ireland, the Northern Ireland Emergency Provisions Act of 1973 had provided that trial on indictment of certain scheduled offences could be conducted without a jury, and these, of course, became known as diplock courts, which were finally abolished in 2007. So it has happened before. It is not that when you look at this whole area, it is completely free, completely new, and nothing had gone before. The point, of course, is to look at the situations in recent times, and there are two cases which are very important for you to look at. They're the JSM&R case and certainly the KS&R case as well, in looking at this whole idea of having a trial without a jury and what its implications are. As I said, the courts, Lord Judge, the senior judge, has said that it does not affect a person's rights per se. Now, what I would suggest you do is to consider the background of the jury and whether or not this idea of moving in the direction of having a trial without a jury does indeed sets up a cause for concern, or whether or not it's no more than a storm in a teacup. That brings me, of course, to the end of this law session on jury, and I would certainly ask you to consider various. There are some articles out there, for example, looking at whether juries are fair, whether or not having a jury in a trial is something that should be bemoaned. I would suggest you consider it in your reading. That brings me to the end of this law session.